Thank you very much. The benefits of artificial intelligence and the need for an ethical approach are a top trending and demanding issue, and we will be talking about it later on the afternoon. The dive we took yesterday made me think as an outsider that when we are talking about e-justice, we are talking about very different things and needs and ideas. E-justice can mean the digitalization of procedures in order for the legal system to work better. This is for the effectiveness. E-justice can also mean the tools that the states deliver to their citizens in order to take advantage of new technologies. This is for approach to the people. E-justice can still be the need to fulfill the vital role of law in increasingly fast societies where the sense of speed takes an important role on the public perception of democracy. This is for the core functioning of the states. E-justice can also be a question. How does justice work facing crime, abuse, or fraud through the algorithms? This is for the technical ability of all justice players. Most of these are present throughout the agenda of this conference, and we are deep diving into it right now. I give the floor to Alain Pilette, Deputy Director Justice, DG, from the Council of the European Union, speaking about the past, present, and future of e-justice. Good morning and welcome.
Good morning, ladies and gentlemen. I propose we start the day with a little bit of history and perspective. The long journey made by European e-justice up to here and some plans for the future. So let's move back first to the 70s, more precisely in 1974, when the Council of the EU established the Working Party on Legal Data Processing, composed of representatives of each member state. This Working Party in the 70s then launched work on the need to achieve greater consistency in access to online legal data and the management of those data in the member states. Remember, in the 90s, a meteoric shift towards the information society was occurring. The introduction of new technologies and the progressive availability of national legal databases in the member states allowed European citizens for the first time to have a direct access to the law in electronic form. So this situation, this technological situation, prompted the Working Party on Legal Data Processing to ask the Publications Office, which is a very strong partner, to develop a standard search interface for national services. This project at the time was named NatLex and became NLex, that you maybe know and hopefully use. It allows any citizen to access the legislation of any member state in a user-friendly way. This initiative applied to EU law too and developed into EURLEX, which I hope is a tool that you use too. In 2000, the remit of the Working Party was expanded in order notably to encompass the promotion and alignment of practices in the member states concerning legal data and its access for the citizens. Then the ambition grew, and in June 2007, the Justice and Home Affairs Council decided that the use of information and communication technologies in the field of justice should be developed at European level. Member states developed pilot projects, and in particular one concerning the European e-justice internet portal. Again, I hope you have already visited the internet e-justice portal. This portal went online in 2010. It provides access to legislation, case law, and legal information. In 2008, the Commission published an important communication entitled Towards a European e-justice Strategy. The view of the Commission was that, firstly, the use of new technologies would help to rationalize and simplify judicial procedures. Secondly, the use of an electronic system in this area would reduce procedural deadlines and operating costs. And finally, access to justice would thus be facilitated. In 2008, the works started being framed by the adoption of eJustice strategies and action plan by the Council, covering periods of 5 years. We have had 3 action plans, 2009-2013, 2014-2018, and now 2019-2023. The work of the Working Party has expanded during those action plans, with projects now being recognized as central to the development of justice in the EU, and that conference is an illustration of that importance. 2 principles guiding the action of the EU eJustice stayed constant across the years, across the 3 action plans. The first one is the voluntary participation of the member states. So you understand that the widest possible participation among them is sought. And I must add that their participation, the participation of the member states, become mandatory when imposed by a legal instrument. And we are working on that. We'll come back on to this point. Then the second principle is decentralization. This is a very important principle that has a lot of implication on the technical side of the project. So decentralization means, in practice, interlinking national systems in the member states without central information hub. Actually, it is even a decoupling vis-à-vis the national procedures. The exchange of data between member states is based on a cooperation model that is not intrusive for the EU member states, which keep their own procedures. Some new principles have been added in the current 2019-2023 European eJustice strategy, and I would like to mention only 2 of them. Firstly, the need to consider the rapid technological evolution in legal tech, such as artificial intelligence and blockchain technology, and I will come back to that too. And the cooperation with practitioners. Practitioners being judges, lawyers, bailiffs, notaries, experts, mediators, they are essential stakeholders, and their involvement is essential for the success of a European eJustice. The objectives we pursue, according to the current strategy, are the continuity of those expressed since 2008 that I have mentioned earlier, that improve access to information, e-communication, and interoperability. So access to information in the field of justice first. It means information on rights, law, procedures, competent authorities, national registers, etc., mainly through the eJustice portal and the interconnection of the databases and registers of member states, such as, for instance, business registers and land registers. Then e-communication in the field of justice. It is about providing an easier and faster access to courts and extrajudicial proceedings by using electronic communication tools and providing electronic communication between judicial authorities and with the parties in judicial proceedings. Then the third objective is interoperability, which refers to facilitating the interconnection between the member states' system. You remember, I said that each member state keep its national system, but they need to be interconnected and being interoperable. Some achievements now I would like to share with you. In addition to the eJustice portal that was launched under the first action plan 2009-2013, I have already mentioned the eJustice portal. There are several achievements I would like to mention specifically. First, ECLI, European Case Law Identifier, that was launched in 2008, an identifier for court decisions in Europe. The ECLI framework contains a set of uniform metadata to improve search facilities for case law. And its complement for law, for legislation, ELI, European Law Identifier, being a system to make legislation available online in a standardized format based on a unique identifier for each piece of legislation, so that it can be accessed, exchanged, and reused across borders. These 2 identifiers are in particular important for search tools and for artificial intelligence processing of legislation and case law. But there is a project I would like to broach more in detail, and it is the one on which we concentrate our efforts for the moment, E-Codecs, which was mentioned yesterday in the opening speeches, and again today by Ms. Leitão Marques. I am the first speaker today going a little bit more in detail on E-Codecs. So I think I must explain a little bit what it is for those among you who are not familiar with it. Since the beginning of the EU eJustice adventure, it was obvious that technical aspects were core in the eJustice project. Decentralization, as I've just told you, is one of the principles guiding eJustice. Only a decentralized information system could be envisaged, taking into account the different judicial systems of the member states. Already in 2007, in Dresden, a large majority of the EU Ministers of Justice expressed the desire to create a decentralized system at European level, which would interlink the systems existing in the member states. That was the first step towards E-Codecs. But this implied solving a number of horizontal technical issues, you imagine. Let's see the main three issues to be solved. The highest possible degree of compatibility between the various technical measures selected for the judicial systems applications had to be ensured, while in the meantime guaranteeing that the member state had a maximum flexibility. It was, however, necessary to reach agreement on standardized communication formats and protocol, allowing for interoperable, effective, secure, and rapid exchanges at the lowest possible cost. Second issue, authentication mechanisms had to be put in place. One of the essential conditions for the effective use of eJustice across national borders, enabling courts and practitioners to communicate with IT tools, was the development of standards interfaces for mutual authentication of the access points and the use of electronic signatures in order to ensure the integrity and authenticity of the data exchange. Then the third technical issue was security of the system and data protection. That was core elements. The data had to be exchanged in a secure way. All these aspects made it necessary to lay down the procedure for choosing the technical standards that could be used to enable member state system to be interoperable. This led to the creation of E-Codecs. E-Codecs means eJustice communication via online data exchange. And the next speakers today will concentrate on this. E-Codecs was launched under the multi-annual eJustice Action Plan 2009-2013 with the objective to promote the digitalization of cross-border judicial proceedings and to facilitate the communication between member state judicial authorities. It facilitates secure communication in civil and criminal matters by the cross-border exchange of electronic messages in the area of judicial cooperation. So the E-Codec system in practice consists of a package of software products which can be used to set up an access point for secure communication. Access point using E-Codecs can communicate with other access points over the internet via a set of common protocols with no central system involved, which means without central supervision. Each access point can be linked, for instance, to a national case management system in order to allow it to exchange requests and documents securely with other similar systems in another member state. E-Codecs was developed by 21 member states with the participation of enough third countries and organizations between 2010 and 2016, and currently is managed by a consortium of member states and other organizations financed by an EU grant. So E-Codecs currently facilitates electronic communications between citizens and courts and between member state administrations in some cross-border civil and criminal procedures. So far, 10 member states have participated in pilots for the use of E-Codecs in different legal procedures. The number of cross-border proceedings where IT communications will have to be used will certainly increase soon. A horizontal initiative from the Commission is under preparation that would foresee IT communication in several judicial cross-border proceedings. So moving from voluntary participation to mandatory participation to IT communication system. For such a progress to be made, we must ensure a stable future for eCodecs. It is why the Commission has made a proposal for a regulation allowing the transfer of eCodecs to EU-LISA. So from that consortium managing eCodecs to EU-LISA, the European Agency for Operational Management of Large-Scale IT Systems, and mandating this agency to provide for the system's operational management. Stable governance for eCodec system will make it possible to become the default system for exchanging electronic messages for judicial cooperation at EU level. The eCodec system is thus one of the key components of the eJustice strategy to improve access to and the efficiency of justice in the member states. It must be the main tool for secure digital communication in cross-border judicial proceedings. The proposal for regulation on eCodecs organizing its transfer to EU-LISA is currently examined by the Council and the European Parliament. The timing for taking over the eCodec system by EU-LISA is a central element of this proposal to guarantee that eCodec's permanent management can be effectively ensured. Such transfer is due to occur by July 2023. As I have said, eCodecs is the realization of an idea that emerged in 2007 and has been developed by the member states themselves. The motivation among the member states is thus very high, and on organizing the transfer to EU-LISA in such a way to ensure the eCodec system's sustainable management. Under the Portuguese presidency, chairing the eCodecs Working Party of the Council, the file has moved full steam ahead. We hope that the European Parliament is likewise measuring how important it is to meet the deadline of July 2023 for handing over the system to EU-LISA. The transfer of eCodecs to EU-LISA is the outcome of a long process, but it's not the end of it. On the contrary, it means that very soon eCodecs will be ready for an expansion of applications. This implies that we'll have to pay attention not only to the sustainability of the system, but also to its expansion. Regarding the sustainability of the system, eCodecs is designed such as to ensure interoperability among member state systems. After its transfer to EU-LISA, sustainability will entail constant adaptation of the system for future developments. The evolution of technology will necessitate the evolution of eCodecs with inclusion of new security and interoperability features. Then regarding the expansion of the system, yesterday, Richard Susskind insisted on the importance of innovation. It is essential new use cases for eCodecs to be developed. By new use cases, I mean application of eCodecs to new procedures. These new use cases should be developed by the Commission and the member states. It will be necessary to determine which use cases are actually worth developing. Practitioners have the best experience of the use cases. They will have to be involved. Judiciaries will also have to be involved so as to develop the solutions for the courts themselves. Such involvement will take place at national level, but will also require coordination of the member states at EU level, and practitioners and judiciaries will also have to be consulted directly at EU level. This means that the involvement of the practitioners and judiciaries in the works of the eJustice Working Party will be more needed than ever. The Working Party on eJustice could then play a role as a forum of coordination for exchange of views and the sharing of experience between the member states, so that the strategy for future eCodecs use cases can eventually be designed in a bottom-up way, while capitalizing on digital success stories of the member states. This could not only reduce the implementation risk and costs, but significantly speed up the deployment and adoption of new use cases at EU level. But we should not forget all the other ambitions set out in our action plan, such as artificial...
Alain, I'm
yes?
sorry to interrupt you, but I would ask you to please to just shorten as far as you could your last thinking on this issue. We are going to deep dive into the questions you've just enunciated right now about the E-Codecs and who is taking over of it, and will it be the actual consortium or the EU LISA? We are going to have precisely about that two addresses, two speeches, two interventions immediately after you. So please make your final remarks. Let's move on with the busy agenda we have today.
All right. Yes. Yes. So a point I would like to add is the importance of data. These are very important. So I think that the publication of court decision and legislation online and in open access, those are very important data to be used by artificial intelligence. Artificial intelligence being another very important work we have ahead of us. As artificial intelligence can dramatically help the efficiency of justice to improve and access to justice. So I'm not going to develop that today, so that I don't bring you too much beyond schedule. So I will conclude here. Then I would like to pay tribute to all the delegates and colleagues who have brought eJustice up to here today, and I'm sure that it's not the end of it. We have a lot of energy for continuing building a people-centered European eJustice in the eJustice Working Party together with all the partners. So thank you very much.